In this session, we are going to focus on two, Article 12 and Article 13 in detail. Fundamental rights, they are guaranteed by Indian Constitution. Who protects it? It is protected by judiciary, that is by Supreme Court and High Court under Article 32 and 226 respectively. We are going to learn these articles later. Today we are going to focus on Article 12 and 13. Right. So here we know overall that fundamental rights are basic fundamental rights which has to be protected by Indian Constitution against arbitrary power of state. Let's start with Article 12. Here, what is Article 12? Is it a fundamental right? No. It actually in Article 12 and 13 there is no fundamental right. Then what exactly it is talking related to fundamental rights? It is actually defining state. So it defines state. Now why we have to define state in a particular article? Because we are going to use state again and again in part 3 of Indian Constitution, that is in fundamental rights, because whatever fundamental rights are given, it is given against the arbitrary power of state. So who is a state? What is a state? It has to be defined. First of all, so we'll start defining this, okay, and we have to remember this, so better we'll understand it and it will be easy to remember. In this, government plus parliament. Okay, so what is a government? Government is your executive body. This is your legislative body, right, of central government, right? Now when we are talking about central government, on the same line we can say state government also. Second, then again government plus state legislatures. This will be again executive. This is legislative organ of state government. So here we can understand central government and state government this way. Executive and legislative organs of both will be defined as state under Article 12. Done? Fine. Third, if we are talking about central government, state government, can we talk about local government? Because there is a 3-tier in Indian system. So yes, local self-government. So local government is also state. Here you can define, here you can give examples like panchayats in rural area. It will be state under Article 12. Yes. Okay. If we talk about municipalities, again it is a state under Article 12. Yes. Urban areas. In urban areas you will find. After that local government, right? District boards are also there. So again all these are state under Article 12. Now this is fine. This is easy. We have to understand one step ahead. Now fourth one, statutory. Can we say statutory bodies or non-statutory bodies okay, they are also state under Article 12. Now this one is little bit tricky. Again I'll add one more thing, private entity. Okay, here there is a confusion case, right? What we can say, we will make test criteria. Okay, 3 criteria will keep it. First of all, function. If it is a public function, then we can say it is a state. If it is performing, if it has control, good control of government, then again it can be defined as a state. Another, if it is funded, majorly funded by government, then also we can say it is a state. Right? Such combinations we can use and we can try to define is it a state or not. When we are talking all this thing, we can compare with this also. It will be easy to say it is a state or not, and we don't need to remember, rather we can understand easily in exam. Now statutory bodies, such as what we can give example of statutory bodies like this, UIDAI. So here it is Unique Identification Authority of India. It is formed under Aadhaar Act. Aadhaar card Aadhaar identification number is given. So that is working as a public function and under Act. It is formed under Act, Aadhaar Act. That is why statutory body. So yes, it is a state. Now can you say non-statutory body? Sometimes PSU, they are non-statutory body, but they are working as a public functions, or sometimes they are even have a control of government, few major or depending on disinvestment. So yes, we can give example of ONGC, SAIL, like this, which are also non-statutory bodies, but they are state. They are defined as a state under Article 12. Done? Fine. Here also you can give in statutory bodies, there are many examples. CIC, okay, Central Information Commission, we are going to learn in a detail ahead. National Human Rights Commission, so they become statutory bodies and also they are defined as a state under Article 12. Now when we are talking about private entity, now it is a private entity, then how state? Not required. But if this is there and it is acting as an instrument of state, if it is acting as an instrument of state, then again it is a state, defined as a state under Article 12. So here you can give such as example CSIR, okay, Council of Scientific and Industrial Research. Here it is majorly funded by government. Okay, now it is fully funded by government. So here you can see this is private entity, but it is acting as an instrument of state. And yes, it is funded by government. That's why you can say this is also defined as a state under Article 12. So here prelims question can be there to make it little bit difficult. Fine. Now for a mains, it is also can be there if it is in news, such as a few years back there was in a news, there was a controversy related to BCCI and its work, and is it a state or not, and again there was some corruption cases. Because of that this issue was raised. Now by the Supreme Court it was given that it is no more it is not a state, but yes, it does a very important public function regarding cricket and all that, but it is not a state. Okay, so like this there can be some controversies which will pop up, and according to that we can decide it can be in a mains or not. Otherwise it is more focused for a prelims. Here everything is done. Now one more thing I want to ask you, in this you can give case also. Okay, this test is there, so there is a one case law. You can write about case law here. It is not much important, but if you have an idea or at least once you have read, then it is good thing. Okay, there is a case law, old one, and recent one was not very important, but the important one which has given this test, it is Ajay Hasia versus Khilad Mujib, okay, Shera Wardi case of 1981. Okay, this is a case, so you don't have to remember much, but this was the case given. Because of that they have given some test guidelines on the basis of which you can decide it is a state or not under Article 12. If it is in the means, then you can use it, otherwise not required much. Now we'll go for another one in this only, which is so you have to understand UPSC can use that, that they can ask. Okay, the another part is like it is already given. Okay, so we are talking about thing is that judiciary. Now you tell me, judiciary is a state, it will be considered as a state under Article 12 or not? That is the question. Okay, this question they can make complex in our prelims. Now you have to understand few things in this. When it is working, it has a function, okay, adjudication function, means it is trying to judge, okay, and sit and see your fundamental rights are violated or not by state, right? So when it is adjudicating, it is taking decision regarding this, then it will be not considered as a state. As per this function, it will be not state, right? But then what? But if it is doing its administrative functions like, you have to understand, like staff recruitment, they need a staff, and there, if they are violating fundamental rights in this process, then it will act as a state and person can go to the court against state action, right? Here another, like if they are going for some infrastructure related, they also have infrastructure and all that thing projects, so for that there is a tenders and all that, and if in this functioning, if they are again violating fundamental rights of any individual, then individual can go against this and it will be considered as a state, it can go to the court, right? So this is what, when it is acting as an administrative function, working as administrative functions, then it will be considered as a state, okay? Otherwise it will be not considered as a state while adjudication function. Done. This is what the difference is there, which we should know. Sometimes it is a little bit complex, which they can make a statement, a complex statement in our prelims. Now we will see Article 13. Okay, so here we are going to, Article 12 is this much only, not much. You have to remember what is state, who are state, and that's it. Now we are entering into Article 13. This is also very important again, but it is not a fundamental right. Here also they are not talking about fundamental rights. So when will fundamental rights come? It will come from Article 14. Here in Article 13, what we are going to learn, very important thing. If any law, okay, it is inconsistent, means it is not aligning with, or it is taking away, okay, derogatory or derogation, okay, or taking away fundamental rights, okay, any law which is inconsistent, which is not aligned with the fundamental rights, it is taking away your fundamental rights, then such law will be considered as a void, that is nullified, means it will be not allowed, that will be not law. Now according to this, there is a power to whom to check this, that it is inconsistent with fundamental rights or not. It is given to judiciary, we have seen, right, under Article 32 and 26, Supreme Court and High Court respectively. So here judiciary, when they check this thing and they declare if it is not inconsistent, not consistent with fundamental rights, then it is declared void by judiciary, right? So this is what called as a doctrine of judicial review. This is very important. So here Article 13 is talking, it provides doctrine of judicial review, where judiciary will make sure that whatever laws are there, they are not inconsistent with fundamental rights, and if they are inconsistent with fundamental rights, it will be declared void, nullified or cancelled. Done. This is simply what Article 13 is talking. Now what is exactly law? You should know what is law. This is what the doctrine they are giving. We got this thing. Here again you can talk about Article 32 and 226. Again we have to learn this thing in detail, okay, ahead. Now, so what happened in this, we'll see. Here we have talked about, let me see, now we have to see law. What is law? It has to be defined again, okay. So here again there are some types. First of all, you can say permanent laws are there. Permanent laws are there, you know. So it is by state and state legislature or parliament, right? They make permanent laws by act, okay, fine. Second, temporary laws are also there. What is the temporary laws? they are like ordinance, example, right? It is required in particular circumstances or emergency, and it is by governors, state governors, or by president. Okay, so when executive is making law temporary, that is ordinance, it is also considered as law. Done, 1 and 2. Third, here delegated legislation terms you have to understand. Delegated legislation. Now what happened delegated legislation? In this, some bylaws, some rules, some notifications, regulations can be made. Okay, that will also form again law. But what is this exactly? So let's understand this. This is actually, it is legislation is delegated, is given to subordinate office or to executive by central legislature, that is parliament or a state legislature. So whenever they are giving their power of legislation, they are delegating it to lower or a subordinate, you can say a subordinate body or even executive, then it is called as a delegated legislation. So here they can make rules, laws, notification by this. Such as example we can see Environment Protection Act is an act made by parliament, right? It has given power to central government, delegated legislation. What they have given power to central government? Executives, right? They have given power to them that they can make rules, laws, all these things. Such as under Environment Protection Act will get e-waste management rules, like that. So that is also considered as a law under Article 13. Done? This is okay? Fine. Now we have to understand one more step ahead. Here it is the fourth one we'll see, that is customs. This was the question asked in a prelims. Why customs? Because they are you can say non-legislative nature. Yes, it is a non-legislative nature. So when it is a non-legislative nature, then it is a state, then again it is a law or not, that is little bit difficult. Yes, confusion can be there. But some customs or customs which act as a force of law, then it will be considered as a law, especially in a tribal areas also. Okay, so yes, this is also law defined under Article 13. Now all these things we have to remember. Okay, another, because it can be asked in a prelims, and this year only 2026 they have asked question regarding this. They have asked very simple concept but in a complicated language form. If you know the concept, it is very easy to answer that. We'll see that question definitely. Okay, so here we have one more thing which we have to understand. Okay, now there is a constitutional amendment which we are going to learn in a detail. So when you amend constitutional, there is a constitutional amendment acts. Okay, is it a law then under Article 13? So they said no, it will be not considered law under Article 13, so it cannot be challenged. Okay, now but there was so many controversies we'll find, and we'll learn that case laws regarding it also, when there is a tussle between parliament and judiciary regarding all this amendments, and also doctrine of basic structure we are going to learn in detail. So here just try to understand what they have concluded for this thing. Okay, by 1973 Keshav Nanda Bharti case. Okay, so according to this they have said कि okay, Constitutional Amendment Act, it is not law under Article 13, it cannot be challenged, but there will be application of doctrine of basic structure. Means basic features of constitution, okay, whatever given in fundamental rights, if it is violated, then that can be challenged in court. That is what conclusion they have given in this. So here constitutional amendment will be not considered law under Article 13, but it has to follow limitation of basic structure doctrine. Means if basic features regarding fundamental rights are violated, then it will be considered as a void or nullified, right? And it can be challenged. Done. This is what the conclusion regarding Constitutional Amendment Act. It is law or not under Article 13. Done. Here we are going to learn in detail in future this doctrine. It will be better to understand this that time. So I'll wind up here and we'll go for a main fundamental right. We'll start exactly from Article 14. Okay. See you then.